This is a lecture from OpenTuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
Just for the sake of completeness, the advanced warning, do not even think about trying to remember years of cases, names of cases, section numbers of acts, titles of legislation. You don't need them. Go on. So here we are now to still partnership law, but this time we're looking at the dissolutions of partnership. Having created a partnership, remember it's the relationship that subsists between two or more people carrying on business in common with a view to profit. Having created a partnership between you and me, at one stage we had a partnership of 5, didn't we? Trying to get rid of that 5th one. Having created a partnership, we now need to be aware of ways in which partnerships come to an end, because partnerships are not like limited companies. A limited company has an indefinite existence, that members of shareholders can come and go, directors can be appointed, resign, die, leave, whatever, but the company survives. Not so with a partnership. A partnership does not have a separate legal identity, and therefore there are ways in which sometimes the partnership, the firm, is automatically killed. It automatically ceases. And there are other situations where, on application to the court, if the court thinks fit, then the court will dissolve the partnership. The court will say, your firm is finished. So that's what we're looking at here. We're looking at automatic and by court order dissolutions. And the first one is death. Automatic. It's an automatic ground for dissolving a partnership. You, me, and 3 others were in partnership. One of them dies. Boom, partnership is ended. Now, where does that leave the other 4? And the answer is, well, we can agree within the agreement that on the death of a partner, that's the end of the agreement. It is. There's no arguing. It is the end of the partnership. But on the event of the death of one partner, the remaining surviving partners shall be able to carry on using the firm's name. So it's almost a seamless transition. Of course, we would need, as the surviving partners, we would need to do an account reckoning in order to compute the amount that is due to that deceased partner's estate. But at least we can carry on. Now you're going to turn around to me, and I hope this has crossed your mind, and you're going to say, what about a partnership like PricewaterhouseCoopers, where there are in excess of 12,000 partners worldwide in the firm PricewaterhouseCoopers? And the answer is, well, yes, the partner, well, there are a number of practical elements there, but when a partner dies, and clearly in 12,000 partners worldwide, there will be partners dying, I'm sorry about this, but on a quite regular occurrence, quite regular occasion. But there will be within the agreement that as long as we make an account reckoning and pay off the estate of this deceased partner, the remaining partners should carry on. There is another element of this, of course, and that is that PricewaterhouseCoopers and all the big 4 firms, so far as I'm aware, big 5 firms now, so far as I'm aware, their name is a franchise, that firms within, not picking on any particular country, indicating in any way that it is less able or of lower status, but let me use as an example Kazakhstan. A firm in Kazakhstan may have acquired the right to use the name PricewaterhouseCoopers, in which case there will be a local PricewaterhouseCoopers Kazakhstan partnership. It may be a total STAN partnership. It may be Kazakhstan, Tajikistan, Uzbekistan, Turkmenistan. It may be all of them added together. So a STAN partnership. I believe in the Baltics, the PricewaterhouseCoopers partnership is made up of the Estonian, the Latvian, and the Lithuanian firms as a single partnership. So when one of those partners dies, it doesn't affect all these partners in America. Possibly does mentally, oh dear, another partner has died. but otherwise no. So death, automatic dissolution. Insolvency, where a partner declares themselves bankrupt. The partner says, I'm bankrupt, I can no longer continue, I have no money, I'm broke. Then in that situation, you can't have a bankrupt partner, because partners have unlimited liability for the debts of the firm. So if you and I are in partnership and I declare myself insolvent, then it's no good the creditors of the firm looking to me, because I have no money, I'm bankrupt. So the law come looking for you. Oh, how would you like that? So the insolvency of a partner is a ground to automatic dissolution of a partnership. Sending notice. In a partnership at will. Now, do you remember I mentioned partnership at will when I was looking at that mnemonic ACCA ISCGT? The T was the time period. If there is no predetermined time period, then that's a partnership at will, and it's dissolvable by any one partner sending notice to all the others and saying this partnership will cease at the end of this month. So the sending of notice is an automatic ground for the dissolution of a partnership. The share of the firm is pledged by a partner to settle his or her private debts. I live in a big house, I live in a huge house. Hundreds and hundreds and hundreds of windows. And of course, I can't be up a ladder every day cleaning windows. So I employ people. And the window cleaner said to me just last week, he said, that's £14,000 that you owe me. And I said, well, look, I'm sorry, but I don't have any cash with me. In fact, I'm struggling actually. Until I get my money from the partnership, I'm struggling to pay you. Listen, will you accept my share of partnership profits in settlement of your debt? So when my share of the partnership profits, or my share of the firm, is pledged in order to settle my private debts, it's tantamount to being bankrupt. And in that situation, automatic dissolution. I'm just going to wipe out private debts because I don't want it to impinge upon the area where I've got to write this next one. The next one is where the object of the venture is ended. You and I enter into a partnership to promote our furniture making business. And the promotion agreement that we've done is to take a stall at the local trade fair. But that's our partnership, is to take a stall at the local trade fair. You want to promote your furniture making business, I want to promote my furniture making business, but we have agreed that we will jointly operate a stall at the trade fair. It's a joint venture. And a joint venture, you'll come across the word joint venture in accounting, in the accounting exams, and the financial accounting exams. A joint venture is defined as being a partnership of a limited nature. It's a partnership for some course of trade, voyage, or adventure. So a joint venture is a partnership. And once we've entered into this agreement, this joint venture to operate a joint stall to promote our separate businesses, then at the end of the trade fair, the object of the venture is ended, and that's the end of our agreement, that's the end of our partnership. So we don't have to specify a time period other than say, the object of the venture is ended. Lapse of time. Partnership for 5 years. At the end of 5 years, that's it. Partnership, it's automatic. No questions, no element of doubt, there's no subjectivity involved. In fact, can I lump all those 6 together and say, these are all automatic, those 6, and they're all very much objective. There's no element of doubt about death. You kick the person and it doesn't move other than from the force of your kick. They're dead. You're insolvent, you've declared yourself bankrupt. You've promised your window cleaner your share of partnership profits. Notice has been received from all these other partners telling me that the partnership is ended. The object of the venture, the trade fair is finished, or the 5-year period is finished. They're all objective. There is no question in anyone's mind that this is the end of the partnership. But these next ones, these are all subjective. These are all by court order. These are all, I have to demonstrate to the court that there is a good reason for the court to tell me that the partnership is finished. So these subjective ones are all as a result of approaching the court and arguing your corner. And there may be other partners coming along and saying, whoa, no, that's not strictly true. And so we're in a disputed situation looking for a court order. I'm going to cross out subjective. It's correct. I'm just going to wipe it out because it might otherwise get in the way of me writing. So subjective, objective, the first 6, subjective, the last 6. And you may think that when I get down to the end of these last 6, you may think possibly that 1 or 2 of them are a little bit contrived just to fit in the mnemonic dissolutions. Well, you may be right. Okay, so unable to carry out one's obligations under the partnership agreement. If you and I are in partnership and we've agreed to run a chauffeuring business, and you lose your license, then you're no longer able to carry out your obligations under the partnership agreement. You may say, that's not fair. Out of my own pocket, I shall employ someone to do the driving for me. That may or may not be acceptable to me. So if I don't like that idea, I will go to court and ask. I did loss of qualification, therefore, loss of some necessary. I did used to use an analogy of a ski instructor losing their legs, but having watched the Paralympics recently, I can see that that's no longer an appropriate example, that a ski instructor can still be a ski instructor even though they may have lost both their legs in some horrific accident. It's an amazing concept, but nevertheless, it's a possibility. Termination is this next one. I'm crossing this out because it's in the way, but it's not wrong. Termination by the court. This is really a catch-all. Termination by the court under the principles of just and equitable. Where's the right thing? Well, the court thinks it's the only sensible thing to do. None of the other grounds that are available would seem to fit. But overall, the sensible and fair and just thing to do would be to terminate this partnership agreement. So termination by the court under the principles of just and equitable. Insanity. 5 of us in partnership and 4 of us think that this other Well, the one is insane, he's mad. So we go to court and say, will you dissolve the firm, please? And then we can count up how much each is owed. And will you give us a dissolution order? The court says, why? We say, because we think this fifth one is insane. And they get the fifth one in court and say, are you insane? He says, no. Well, that will probably say, but it's subjective. I can think of 3 firms in Manchester alone. While I was working in Manchester, I could think of 3 firms where partnership agreements, partnerships were dissolved and then set up again without the madman, without the insane partner. So insanity is a subjective one. It needs to be proved to the satisfaction of the court. It's not automatic. Some of you know partners in partnerships may agree with that. It's not an automatic ground. Only able to, where's he gone? Only able to carry on at a loss. Again, that's subjective. It may be that 15 years ago you and I set up a partnership and we never once have we made a profit. We're just not very successful. So you may say, look, Mike, this is disastrous. We're only able to carry on at a loss. And I say, no, good times are around the corner. Dispute. We're in dispute, we're arguing, we're in court, and you say we can only carry on at a loss. And I say, I think he's wrong. I think when we get a new supply of dinosaur eggs, we shall be able to recommence our marketing activities. So it's up to the courts then to decide who's got the stronger argument. And the court may agree with you and say, partnership dissolved. Or may agree with me and say, no, I'm sorry, but we think you're going to have to continue. You may choose to leave then. You may choose to dissolve the partnership, but you went to court hoping that you're going to get the court to determine, for instance, the value of goodwill, which we might not have agreed upon in our partnership agreement. Nefarious conduct or naughty conduct. Conduct that is calculated to affect the carrying on of the partnership prejudicially. There was a partner from a Big Four, I'm not going to name the Big Four firm. There was a partner from a Big Four firm a number of years ago now who was caught by the railway police dodging his fare. He lived on the south coast, travelled in, commuted in every day. And one day he didn't have time to buy his ticket, he only just caught the train. And when he got off in London, he paid the fare, which you could do. You could pay to the ticket collector. I'm sorry, I don't have time to get a ticket. So the ticket collector says, where did you get on? And instead of saying Brighton, he said, I got on at Stratford, an area of London. I got on at Stratford, which is only like 2 stops down the line. So he paid his £5, whatever it was, instead of paying £30, whatever it was. And he realised that he could do this and save himself a whole raft of money. And the railway police a ticket collector got suspicious, and the railway police followed this man back to Brighton one night. And they sat on the railway platform overnight in sleeping bags. And the man appeared at 6:20 to catch the 6:30 train, and they got out of the sleeping bags and went onto the train and followed him. And as he said to the ticket collector, I didn't have time again to collect my ticket this morning. And the ticket collector said, where did you come from? He said, Stratford. And there was a tap on his shoulder. He said, excuse me, sir, we just followed you from Brighton. And he was a partner in a Big Four firm. Conduct calculated to affect the carrying on of the partnership prejudicially. If you look in accountancy magazines, and particularly the magazine Accountancy, there is frequently a report from the disciplinary committee. And I remember one from about 25 years ago about an accountant who lost his qualification by the disciplinary committee. They'd taken his qualification from him. I don't know if he was a partner, but if he was, he very quickly wasn't. And this man had a fetish for collecting ladies' underwear. And he would patrol the streets, the estates in Leeds, in Yorkshire. He would patrol the estates in summer evenings and see if washing was on any washing lines. And he would jump over the garden fence or open the gate, rush in and grab some pieces of underwear and rush out again. And he was caught, and he was an accountant. Conduct calculated to affect the carrying on of the partnership prejudicially. Naughty, nefarious conduct. Subjective. You have to take him to court. He said, we think the partnership should finish. He said, no. Why? Just because I've been collecting women's underwear? Why should that be a ground for ceasing the partnership? Yes, okay, my name is in the newspapers, but hopefully the clients won't see this. Have to go to court. If he argues, we have to go to court and say, finish, get rid of him. The last one is shirty conduct. When a partnership is persistently, repeatedly in breach of their obligations under the partnership agreement, if it's agreed that they should be producing monthly accounts for distribution amongst the partners for us to read and assimilate and peruse and consider at the next partnership meetings, and they're consistently, there's one person whose responsibility it is to prepare these partnership figures, persistently in default and arguing about it. I don't see why I should, but it's in the agreement that you should. Yeah, but I don't think we should change the agreement. It's in the agreement, and until we change the agreement, you are required to produce monthly accounts. Well, I don't think I will. Well, this is shirty conduct. This is argumentative. This is conduct which is not helping the partnership. So where a partner is in persistent breach of the partnership agreement, we can go to court and say, will you help us to get rid of this person? Will you help us to dissolve? Now, you may say, in all of these, you may say, well, why not just give notice? Well, it may be a partnership at will. Sorry, it may be a partnership for a fixed term, in which case it's for a fixed term, and we're trying to break that fixed term contract. So these subjective ones, where we have to satisfy the court that there are reasonable grounds for the court to issue a dissolution order, these are all subjective. First 6, objective: death, insolvency, sending notice, share of profit charged, object of the venture is over, lapse of time, dissolve, all objective. Utions, unable to perform on share of the partnership agreement, termination by the court under the principles of just and equitable, insanity, only able to carry on at a loss, naughty conduct, shirty conduct, all subjective. LPA, Limited Partnerships Act of 1907, and the LLPA, the Limited Liability Partnerships Act of 2000. Obviously relatively recent, but certainly not as old as the 1907 one. Limited Partnerships Act 1907 still exists. There are still limited partnerships. It's not been replaced by the Limited Liability Partnerships Act, so we do need to know about it. Main features: at least one general partner who has unlimited liability, and at least one limited partner who has a limitation on their liability in the event that the partnership is dissolved. Got to be registered with registrar. The limited partner takes no part in the management of the firm, and if they do, they become liable for the debts and liabilities incurred during the period that they were taking part in management. Now, they can give advice. They can sit in a partners' meeting, and this limited partner is sitting there saying, ladies, gentlemen, if I may interject here, I suggest that what we could think about doing as a partnership, and they can look at him and listen to him, and they can hear his advice, and they can say, right, thank you very much. but we're going to carry on our own way. So they don't have to take his advice. So giving advice is not taking part in management. But where he comes in and hires and fires and sells and buys and deals with customers and clients, that's taking part in management. And any debts and liabilities incurred in that period, he becomes liable for, as though he were a general partner. As a limited partner, death, insolvency, and insanity have no effect on the carrying on of the partnership. He could do all three. He could be insane, bankrupt, and die, and he still would have no effect on the continuation of the partnership. As a limited partner, this fact must be noted on the note paper, lists all the partners, and then A. Smith brackets limited partner. So it has to be brought to attention. So no creditor is going to be looking for compensation from the limited partner. They contribute a fixed stated sum by way of capital into the partnership. That's their capital contribution. But the limitation of their liability characteristic says they shall not be liable for any more. So in the event of insolvency of the partnership, don't come looking to these limited partners for any contribution. That's why we have to have a general partner, someone, at least one person, with unlimited liability. Now, if this limited partner withdraws some element of their capital, so let's say they have a 5,000 contribution, beyond which they shall not be liable. You can't ask them to put in any more. If they take 2,000 out and leave themselves with just 3, and then the firm goes into an insolvent dissolution, then this limited partner becomes liable to re-contribute that 2,000 they have previously drawn. But no more, just that 2,000. So that's Limited Partnerships Act of 1907. Limited Liability Partnerships Act of 2000. This is an attempt, quite a successful attempt. Ernst Young in the Channel Islands, I think, were the first ones to take advantage of this. And the concept behind this is that the major characteristic of a limited company is that there is a limitation of liability for the members of the company, whereas partners didn't have that protection. So the Limited Liability Partnerships Act has taken this wonderful characteristic of company law and the wonderful characteristics of partnership law and merged the two. So they've taken the better characteristics of these two separate elements and joined them together under the Limited Liability Partnerships Act of 2000. So in detail, combines the advantages. Partnership must be registered again, must file financial statements which must be audited. These others, limited partnership, must be registered, but they don't have to file financial statements. These must be audited, these must file financial statements, and these must be audited. And as a separate legal entity, the partners are not liable for the firm's debts, thereby protecting themselves, ring-fencing their personal wealth. In any other partnership, general partnerships in the Limited Partnerships Act, general partners in a you and me type partnership, we are unlimitedly liable, right down to the value of our private estates. You're allowed the clothes that you stand up in, and apparently you're allowed the roof over your head. But it doesn't have to be the same roof as your mansion that you're living in at the moment. You're allowed our roof, I think, over your head. But otherwise, everything must go. So as a separate entity, partners are not liable in an LLPA, in a limited liability partnership. Partners are not liable beyond they're not unlimitedly liable for the firm's debts. Provisions relating to wrongful and fraudulent trading, which we will come across when we start looking at illegal activities within company law. In that situation, the provisions relating to wrongful and fraudulent activities do apply.